So we have an important update in the Vanderstock frames and receivers case. The ATF has now filed for Supreme Court review, and the Supreme Court is now set to consider this issue. So let's talk about what is happening. But real quick before we jump into this video, if you think the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to give a shout out to one of the main supporters of this channel, which is First Form. First Form is an amazing company. They are supporting me and helping me along with my health and fitness journey. A lot of you guys are aware that I've been losing some weight over the last couple of years. I'm still doing that. And one of the companies I'm working with is First Form. They have amazing supplements. Their protein is amazing. A lot of their products are amazing. And one of the cool things that they're offering you guys is if you sign up and you're signing up for the first time using the code and link down below, you can get 30 days of a free trial of their new health app. So again, check out First Form, amazing company. They believe in the Second Amendment and what we do here. And thank you again to First Form for sponsoring and supporting this content. Now, as I mentioned in the intro, in this video, we're gonna be discussing an important development in the ATF frames and receivers case that we've talked about a lot, which is called Vanderstock versus Garland. The ATF has filed for Supreme Court review in the frames and receivers case, and now the Supreme Court will get together and they will consider whether or not they should grant review to this case and ultimately strike down this rule, and they're going to do that at conference on April 12th. This Vanderstock case may be the next major ATF overreach case that the Supreme Court will ultimately review and decide whether or not they want to limit what the ATF is doing. This critical review is happening because the Fifth Circuit recently handed down its decision on the summary and final judgment of this case. The Fifth Circuit panel recently decided and partially upheld a lower court ruling, but also vacated it partially because the Fifth Circuit believed a vacatur of the entire rule nationwide was beyond what the lower court could do with its powers. Now, because of that recent 3-judge panel, the ATF was kind of in a hard spot and they only had a few options. They could either file for en banc review in the Fifth Circuit, they could try to bypass that and seek review immediately from the Supreme Court, or they could just send this back down to the lower court and let the lower court deal with it back on a remand. I predicted, looking at some of the lower court filings, that the ATF had decided that they wanted to go to the Supreme Court immediately. They wanted to bypass the Fifth Circuit en banc panel, and that's exactly what they did. They filed for Supreme Court review. The ATF is hoping that the recent 5-4 emergency stays that the Supreme Court issued in their favor in this Vanderstock case, that will ultimately lead to a favorable decision on the merits of this lawsuit. But in my opinion, that's a huge mistake that the ATF is making. They are just assuming because the Supreme Court issued 5-4 emergency orders in their favor that they will then ultimately rule in their favor on the merits of this case, and that's not true. Now, to understand what is at stake in this case and why the Supreme Court's hands will ultimately kind of be forced to have to deal with this case, we need to talk about how this case developed and how it made its way eventually back up to the Supreme Court. Originally in this case, the Plaintiffs, Firearms Policy Coalition, and Tactical Machining sought preliminary injunctions to halt the enforcement of the ATF's new rule against unfinished frames and receivers. On review, Judge Reed O'Connor granted a limited preliminary injunction against the ATF, which ultimately prevented the ATF from enforcing that rule against Tactical Machining and its customers. Looking at the ATF's rule on frames and receivers, Judge O'Connor found that it was facially invalid under the plain text of the statute, and that Congress did not grant the ATF authority to regulate these types of items. Now, after the preliminary injunction stage, the plaintiffs in this case decided that they wanted to win the entire case, and they sought a motion for summary judgment. And in response, Judge O'Connor did grant the motion for summary judgment in favor of the plaintiffs, the companies, and their customers. And ultimately, the judge did grant and ultimately vacated the entire frames and receivers rule nationwide. So that was a huge win. Well, of course, the ATF was not going to let that summary judgment sit. They were not going to let that nationwide vacatur sit. So they filed an appeal up to the Fifth Circuit. Then the ATF sought a stay from the court so that they could still enforce the rule while the summary judgment was being appealed in the Fifth Circuit. However, both the lower court, Judge O'Connor, and the Fifth Circuit 3-judge panel denied the request for a stay. That then led the ATF to going to the Supreme Court on an interlocutory emergency basis for the first time in this case. So there's been a few times now that the ATF has taken this case up to the Supreme Court. This was the first time with an emergency request. And in a 5-4 decision, the Supreme Court agreed to stay the enforcement of that nationwide vacatur. And in that 5-4 decision, it was Justice Barrett and then Justice Roberts who joined the liberals to side in favor of the ATF. Now, after the Supreme Court issued that 5-4 emergency stay, 80% Arms and Defense Distributed went back down to the lower court, went back to Judge O'Connor, and sought an emergency motion for a new preliminary injunction. They asked for Judge O'Connor to put back in place that limited preliminary injunction that was already in place. They wanted that limited protection just for their company and their customers. On review, Judge O'Connor agreed and ultimately granted the injunction to protect the companies and their customers. Essentially put back in place that limited injunction, which protected all of those plaintiffs. And again, in response, the ATF went back up to the Supreme Court, for the second time on an emergency application to the Supreme Court, asking for the Supreme Court to vacate that new limited injunction. And for the second time, the Supreme Court sided with the ATF and struck down that limited injunction. The Supreme Court, through these two 5-4 orders, prevented any positive relief in this case while the summary judgment was being reviewed by the Fifth Circuit. The Fifth Circuit, really could issue a new decision, but no positive relief, no limited injunctions, no nationwide vacature of this rule could really do anything until this case made its way back up the Supreme Court. The Fifth Circuit recently did decide on the merits of this case, and in their decision, the panel partially upheld what the lower court said. They upheld what Judge O'Connor said, and they struck down the ATF's rule. After the Fifth Circuit decision on the summary judgment, the question was, what would the ATF do? Because really, they were between a rock and a hard place. They didn't have a whole lot of options. They could try to take the case to the en banc panel in the Fifth Circuit, but they had lost previously in cases like Cargill dealing with the whole ATF overreach issue. They had pretty much lost at every level in this case, except for the emergency requests that went to the Supreme Court. And so that was also an option. They could try to bypass the Fifth Circuit en banc panel review and just go directly to the Supreme Court. I anticipated that's what they would do, and ultimately that's what they did. The ATF filed their petition for the Supreme Court to review this case and to ultimately strike down this nationwide vacature of the frames and receivers rule and find that what the ATF did was in fact lawful and that it is a valid rule. So the Supreme Court now has another Second Amendment ATF overreach case in front of them. FBC and the plaintiffs have now filed their response to the Supreme Court petition, and ultimately they say that they agree that the Supreme Court should grant review to this case immediately. The plaintiffs state in their response that respondents agree with the government on the proper disposition of the government's petition for a writ of certiorari. They state that they agree with the ATF that the Supreme Court here should grant review to this case and decide whether or not the ATF's rule is expanding beyond the definition of firearm, which is included in other items and other statutes like the GCA and other federal legislation. They are asking for the Supreme Court to review if what the ATF did in the rule-making process in this new rule against unfinished frames and receivers goes beyond the statutory definition like all these lower courts said. They go on to state that while respondents agree that certiorari should be granted, that is where their agreement with the government ends. That is because the challenge provisions of the rule are fundamentally incompatible with the Gun Control Act's definition of firearm. They go on to state that the definition of firearm under the federal law is an important issue that was precisely addressed by Congress in the Gun Control Act of 1968. If that definition has become obsolete or unsatisfactory in any way, that is an issue for Congress to address. The Fifth Circuit properly held that the ATF overreached by effectively attempting to amend the statute itself. The court should grant certiorari and affirm. So FBC, SAF, and all the plaintiffs here and the companies involved in this lawsuit like 80% Arms, Tactical Machining, Defense Distributed, all of them agree that the Supreme Court should take review of this case immediately like the ATF is requesting. However, the Supreme Court should ultimately affirm what the lower court said, what Judge O'Connor ruled, and what the Fifth Circuit ruled, that this new rule by the ATF is in fact invalid and goes beyond their authority and goes beyond the language in the GCA. Currently, briefs and amicus briefs are being submitted to the Supreme Court in this case, and tentatively, this case is set for conference in front of the Supreme Court on April 12th. A conference is simply when the Supreme Court gets together and votes on whether or not they intend to take up a case or if they want to deny cert. So they get together, they vote. I believe they only need 4 votes to grant review to any case. Now, I will say that, the Supreme Court gets a lot of cases sent to them every single year. They only take, a very select few. But I do think this case, based on its posture, based on their intervention early in this case with the 5-4 emergency orders, and also the fact that they recently granted review to Cargill, heard, oral arguments in Cargill, which deals with the ATF's, interpretation of bump stocks as machine guns. I think it's very likely that this case, at the very least, would be held, and at least until the Supreme Court issues their decision in Cargill. Again, the Cargill decision is going to happen before the end of this term. They've already held oral arguments on that. I recommend you guys go watch my video breaking down those Cargill arguments because it's going to be very relevant for what happens in Vanderstock. But again, I think Vanderstock at the very least will be held and then GVR'd after the Cargill decision is issued. My hope, though, is that ultimately the Supreme Court will grant review to this case and once again will go after the ATF and their overreach and their expansive rules which attack our Second Amendment rights. So major developments in this case, in another big case dealing with the ATF's overreach that is now in front of the Supreme Court. If anything else develops, if we get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and a signal to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.